Thank you, Mr. Vice Chair. Thank you, honorable members of the Judiciary Committee. My name is John Wesley, and I'm the Director of Policy at the Rhode Island Coalition Against Domestic Violence. On behalf of our member agencies and through our member agencies throughout the state, we provide services for more than 9,000 Rhode Islanders a year that are victims of domestic violence. And we are here tonight to voice our strong support for both Senate Bill 660 and Senate Bill 274. I'm going to focus particularly on Senate Bill 660 tonight because so far not too many other witnesses have addressed it in depth, and it really affects domestic violence and sexual assault victims in a very serious and dangerous way. I'm referring to the unconstitutional and unenforceable spousal notice language that still exists on the books today, even though it is patently unconstitutional. Senate Bill 660 would finally repeal the 1982 requirement of spousal notification, which is worded as husband notification in the statute, which makes it both sexist and offensively heteronormative. Even though it was struck down in federal court as unconstitutional way back in 1984 in Planned Parenthood of Rhode Island v. Board of Medical Review, the spousal notice statute remains within the Rhode Island general laws. That a husband must be notified before a patient makes her own autonomous reproductive health choices violates fundamental liberty interests under the U.S. Constitution. It is way past time that the misogynistic spousal notification language should be completely and utterly stricken from the books in Rhode Island. Restricting any access to reproductive health services and choices places particularly dangerous burdens on victims of domestic violence. In a 2010 study conducted by UC Davis and the Harvard School of Public Health, researchers found that at least 35% of domestic violence victims report reproductive control by their abusive partner, either by contraceptive interference or by coercion to become pregnant. When the United States Supreme Court found spousal notice measures to be unconstitutional in Planned Parenthood v. Casey in 1992, they based their reasoning on the serious and potentially life-threatening consequences that this sort of law has for pregnant victims of domestic violence. We urge you to consider the court's reasoning, and I quote directly from the opinion of the United States Supreme Court in Casey. Mere notification of pregnancy is frequently a flashpoint for battering and violence within the family. The number of battering incidents is high during the pregnancy, and often the worst abuse can be associated with pregnancy. The battering husband may deny parentage altogether and use the pregnancy as an excuse for abuse. Now, in addition to spousal notification being incredibly dangerous for victims of domestic violence or sexual assault, as well as unconstitutional and unenforceable, I would add that I am a married man myself with a wife who is a physician. She's much smarter than I am, and she's certainly more than capable of making her own health choices. So I believe that the husband notice requirement that is still on the books here in Rhode Island somehow, I believe that this is sexist. It's, of course, in violation of individual liberty and fundamental privacy rights, as well as violating patient confidentiality and autonomy. So thank you for your consideration. We would please urge you to support S-660 and finally repeal this dated and discriminatory law. Thank you.
Do you have any statistics on the number of incidents that the Domestic Violence Coalition deals with regarding the non-disclosure or the disclosure of a pregnancy, and then the retaliatory aspect of it? I ask this because I prosecute for a couple of towns and I deal with domestic violence cases weekly, and lots of them. And it's an interesting concept, a troubling concept that I hadn't quite put in perspective before, even after doing this stuff for years. And we have the former director here in Senator Nesselbush.
Absolutely.
But can you just amplify? I'm not trying to hold you to a hard statistic, but I'm curious. Can you amplify a little bit more on the percentage that you see in the coalition?
Certainly, Mr. Vice Chairman. So due to very strict confidentiality laws, including under the Violence Against Women Act, it's there are protected information, including especially any health or medical records for victims who are in shelters or seeking domestic violence services. So it's very difficult to kind of find openly disclosed public information about pregnancy, rates of pregnancy. We do know that there are certainly more cases of through the studies like the one that I cited from the Harvard School of Public Health, that there is a disproportionately high rate of unintended pregnancy found amongst victims of domestic violence because of pressure from their abusive partner to get them pregnant or to try to interfere or basically take over the choices and the reproductive contraceptive choices that they make, sabotage the birth control that they use, or put pressure on them to have a child to stay in the relationship, using the child and the pregnancy as another threat against them to stay in an abusive and controlling situation.